Hello and welcome to Distilling Cyber Policy. I'm Alex Spotting with Venable and I'm joined by my co-host Jen Ellis of the Center for Cybersecurity Policy and Law. Hello, Jen. How are you doing?
Hey, Alex. How are you doing?
I'm doing okay. It's been a busy few weeks on the travel front, but I am hoping that calms down, and I even booked myself a holiday. Imagine that.
I'm very proud of you. I am very proud of you for that. And you also sound a lot less wrecked than I think I would if I had your recent travel schedule, since you're very freshly back. And I think there is some jet lag, right, from where you've been. So yeah, well done.
Thank you.
So for news today, Alex, just to keep you on your toes, we're doing something we've never done before. I'm quite excited about this. We've got a guest who's come in to talk to us about the news. And in no way is this to avoid reading a 450-page document myself and instead making someone else do it. So today we're joined by Michael Daniel, who, is the CEO, I believe, of the Cyber Threat Alliance. Also a co-chair on the ransomware task force with me. So Michael has the unfortunate distinction of getting to work with me regularly. And many people will no doubt remember Michael for his time in the White House under the Obama administration. He did lots of really great work on cybersecurity as part of the National Security Council. And I sort of think, I don't know what the exact term is, Michael, you have to correct me, but I always think of you as being Obama's man on security, which I'm sure is not the right term.
It's actually the first line of your CV, right?
Yeah, that's right. That's right. Yeah. Thank you for having me. I really appreciate you having me on.
It's great for you to join us. Thank you. And I feel like, I could have carried on introducing you for a long time because you have many, many, many plaudits that, we could speak to, but we have to get on. This news section is meant to be short. So we, Alex and I didn't want to read CISA, so we asked you to come on. and we really appreciate that you've done the legwork. Not for us, I should say. You did it generally because this is a topic you've been working on for a long time and are very heavily immersed in. Can we just start with, for those who don't know what CISA is and why this is in the news section right now?
Yeah, so the acronym CIRCIA refers to the Cyber Incident Reporting for Critical Infrastructure Act, which the U.S. Congress passed a couple of years ago. And it essentially says, if you are a critical infrastructure company and you own and operate an IT or OT system in a critical infrastructure function, you are going to have to report if you suffer a major cyber incident or if you make a ransom payment. And you're going to have to report within a certain time frame. And we've asked the Department of Homeland Security, in the form of the Cybersecurity and Infrastructure Security Agency, to issue a rule that will actually implement this statute. So after several years of work and industry consultation and other things, the CISA has now issued what's called an NPRM, a Notice of Proposed Rulemaking, because we love our acronyms here in Washington, D.C. And so so it's effectively a draft rule. And just to be fair, although the entire package is 450 pages, the actual rule is only about 40 pages. The rest of it,
Alex, we could totally have read that.
Yeah.
How did they come up with 410 additional pages?
Oh, there's all sorts of analysis that they have to do, and there's all sorts of, required bits that go into part of the rulemaking.
God, I feel like if you've got to justify your rulemaking that much, then something's gone desperately wrong. But anyway, that's an aside.
At this point, I'll fess up. I knew it was only 40 pages. I just wanted an excuse to talk to Michael.
In all fairness, it has worked out pretty well. I'm pretty happy with how things have come around.
Yeah, so they've put out the draft rule, and we're now in the comment period. So people are reading the rule and are figuring out how they're going to respond to it. That's why this is news right now.
Awesome. Okay.
And I understand the way that they've sort of laid out the scope in terms of number of companies that are in. It's pretty broad, right? When we talk about critical infrastructure, it's not just those specific entities that are designated as critical infrastructure.
Isn't everything in the US critical infrastructure? Isn't that how it works?
If you read the rule, you could start to be forgiven for thinking that. But yeah, basically it says, it actually goes through and lays out a whole bunch goes through basically almost every critical infrastructure sector and essentially lays out, what entities will be required to report under that sector. And then it sort of has a catch-all of, and if you're not a small business, this also applies to you.
And when you say sector, do you mean is it the 16, right, that are
right.
delineated on the CISA website? So it's those 16, but also if you're not a small business, it's everybody.
Yeah, pretty much. It is very broad. To be fair, I mean, Congress sort of clearly intended it to be pretty broad.
Right.
And, didn't really put much restriction on how you define a covered entity.
Right. I mean, when we're talking about reporting of cyber incidents, I'm not sure that that's a bad thing, if I'm being brutally honest.
I agree, actually. No, I mean, I think one of the primary reasons you want reporting is so that you start to get a better sense of what the incident rate is for cyber incidents across the United States. And you need a pretty good sample size to really get at that question. So the key thing, right, is that one of the issues that we have long identified for CISA in this is there needs to be some expectations set about what does it mean to report? And just because you file a report doesn't mean that the guys in the windbreakers or the women in the windbreakers are going to show up and help you, right? So I think there's some expectations of what happens after a report is filed that need to be set.
And do we have a sense of the volume of reporting? How many reports are we expecting this to generate? Because, one of the challenges obviously is not getting enough information. Another challenge is getting such a huge volume of information that you've then got to figure out, okay, how are we going to translate this into something useful? Do we have a sense of where that's likely to land, Michael?
So I don't think we really do. If you look so part of that other, 400 pages worth of stuff was, estimates from CISA about how many, reports that they think they might get. And the numbers are pretty broad, right? They're looking at everything from, tens of thousands of reports per year to, a couple of 100,000 reports per year.
But this is one of the key things, right? This is actually why we need something like CISA. I'm going to keep saying it as if it's a Roman general. You need it because at the moment we actually truly don't know how much of the iceberg we can see. And until you mandate reporting, we won't know the answer to that question. But that said, I think we can expect that this is very different to kind of what's been suggested with stuff like the update to the Network and Information Systems Directive in the EU, where they want near misses reported. I think in this case where you're just talking about verified actual security incidents, and I'm sure that they've defined security incidents in some way, that's going to be a much smaller number than that view that people have had around the NIS update, which Alex, I'm sure that you had in the back of your head since you've done so much on it, where it feels like that could be just an exponential forever number. You could just keep going and going and going with the near, what is a near miss, right?
Yeah, that's right. And I mean, this under the rule, it's got to be considered a substantial cyber incident. So not only does it have to have actually, near misses don't count. It was blocked at the firewall and nothing happened. That doesn't count. It actually has to have some material of, and I'm using the word material, not in the SEC definition, but just it has to have some real world impact on the entity. And, that's not, I think that's a reasonable place to start. And like you said, Jen, we really just don't know. And that's part of the problem. And I think, once we get into it and start seeing how the numbers start to lay out, we'll be able to do a much better calibration job. And I don't think the fact that we don't know, that's not a knock on CISA. I don't think anyone knows.
Right. No, absolutely. Right. So very quickly, because we should probably wrap up and move on to other news things, but does it look good? Does it look okay? Do you like it?
I do, actually. I mean, obviously, I think there are some things that need to be tweaked and improved, and that's why you have a comment period. But I think CISA has faithfully followed what was in the statute, and they've reflected some of the recommendations. So, for example, the rule allows for what's called supplemental reporting, because everybody knows that the first report has to come in within 72 hours of the substantial incident. And we all know that like in the first 3 days, you have no idea what's actually happening.
Right.
So
everything changes.
Yeah. So it allows for supplemental reporting, and it even allows for an entity to come back and say, okay, we're done. The incident's over. And so I think, it's got a lot of really good pieces to it. And I think overall, it's a very strong draft.
Are there any other sort of like major takeaways that, people listening should have? And like, should people listening look to put in a response to the call for views? Like, what's your view on that?
Absolutely. I mean, I think that, people should look at this and think about whether or not they may, in fact, be a covered entity because it is so broad. And they should start to think about, like, how do you build this reporting requirement into your incident response plan? And how do you actually set up your structures and processes to make sure that you could meet this reporting requirement if it applies to you?
Okay, awesome.
Excellent. That's an incredibly helpful rundown. And whilst any company listeners will probably still need to work their way through the raw, I think for folks who want a more casual understanding of things, I think that's a fantastic sort of high-level set of takeaways. Just a quick plug that on April 17th, the Coalition to Reduce Cyber Risk, which is one of the coalitions that sits within the Center for Cybersecurity Policy and Law, released a new white paper called Guarding Global Commerce, which is all about how cybersecurity is being incorporated into free trade agreements to try and drive better alignment and adoption of best practices. We did a great launch event following up on our briefing that we did at the WTO to all of the WTO delegations there, and we will put a link in the show notes.
Brilliant. And by show notes, he means blog. And okay, awesome. So, Michael, will you stick around to torture us at the end of the episode by being our mystery trivia master?
Absolutely.
Awesome. It's finally your opportunity to get your revenge on me. Cool. All right, thanks. We'll speak to you in a bit. So, Alex, today for our interview, we're getting to meet some new people, which I always love. And also, we're going to learn about something that I genuinely don't know anything about, which I really appreciate because I get the primer. So for listeners, in case you thought this episode was for you, it's really for me. Sorry. So today
we can learn together.
Right. I think that's great. So today what we're learning about is the recent executive order on preventing access to Americans' bulk sensitive personal data and United States government-related data by countries of concern. Just rolls off the tongue. In case you didn't catch all of that, I think you can probably Google search data security EO, but we'll also have a link to it in the blog. But you can also refer to it as Executive Order 14117. I just learned that. And joining us today to talk to us about it are Licata, who is at the Department of Justice working in the National Security Division. He is the deputy chief that is implementing the EO. And then we're also joined by Grant Dasher, who's in the Cybersecurity Division at CISA, the Cybersecurity and Infrastructure Security Agency, and he's the Architecture Branch Chief, and he's working on the security requirements. So it sounds like it is a beautiful teamwork that's going on across government here.
People helping people.
Thank you for joining us.
Thanks so much for having us.
Yeah, happy to be here.
And congratulations on getting the executive order out. So it was out on the 28th of February, is that right?
Yep.
Fantastic. And I mean, it seems like it was probably a huge amount of work. Why don't we start with talking about what it is, what it does?
Sure. So this executive order, you're right, took about 2.5 years to come together into fruition. So a tremendous amount of work just to get to the starting line of having the EO in place. What this does at its core, though, is it authorizes DOJ to set up this new program that will essentially prohibit or restrict certain types of commercial transactions or commercial relationships between a U.S. person on one hand and what we're calling a country of concern or a covered person on the other, where the transaction would afford that country of concern with access to certain types of Americans' bulk sensitive personal data or government-related data. And so for the next year, this is the program we're going to set up.
Okay, so EOs, and like, forgive me, I am not necessarily like the ultimate source of knowledge on all things US policy, but I like to learn. So EOs, they are issued by the White House, right? And they are targeted within the realm of things that you can already do. So authorities already granted to the administration, right?
Correct.
And so they largely cover the behavior of the administration. Is that right? Is that fair?
Correct.
So it's about what the US government is doing and who the US government can do business with. Is that right?
So not quite the US government, right? So it does authorize us to use the president's existing national security authority for the Department of Justice to promulgate regulations that will implement these prohibitions. So the transactions we're targeting are between private sector entities on one hand in the US and these countries of concern or covered person on the other. So this actually governs two buckets of data. The first is broadly American sensitive personal data. So think of US companies that have access to things like Americans' biometric data, financial data, medical data. Right. The other hand is what we're calling U.S. government related data. This is sensitive personal data that pertains to current or former government employees, so think members of the military, intelligence community, as well as precise geolocation around certain sensitive locations.
Okay.
Right. But it's dealing with private business activities that involve this kind of data.
Okay.
So it's more about then the US government intervening on national security grounds to say, we're not claiming this was unlawful behavior before, but we are seeing that private companies are transferring that data in ways that might impact US national security, and we want to inhibit the ability to do that. Is that a fair characterization?
Yes, that is correct. And in fact, that's an important part of why we're doing this, right? Which is that many of these activities are totally legitimate commercial relationships or activities, but present this kind of national security risk, right? So we certainly, and Grant knows better than anyone, have spent a lot of time what we call protecting the back door from this kind of data being stolen through malicious cyber activity. But this is the front door, right? This is legitimate activities that present this kind of risk. So we're trying to make sure both doors are protected and closed.
Right, great. What's the current status of it? Like, is it in effect? Is it proposed? Like, how does it work where it is at the moment?
So the executive order itself is in effect, but nothing changes on day one. So the way that we're implementing this is through our regulatory process. And right after the executive order was signed, the Department of Justice released what's called an advance notice of proposed rulemaking, which essentially is a document that reflects what kind of regulations we're considering, and it proposes questions to the public to collect comments and feedback about how we will shape these rules. The public is currently or is finalizing or is finishing the comment period now on that advance notice of proposed rulemaking. And essentially what will happen is after that, we will digest the feedback we get and issue a proposed rule at some point this summer. And once that proposed rule is out, we will collect comments again, and eventually we'll get to final regulations probably sometime early next year in 2025.
Okay, so it's like a refined process and it's very democratic and people can have their say. So like people shouldn't freak out right now that this is something that's going to be like that they're behind on or anything like that, right?
That's correct. In fact, what we're hoping is that people will want to use this opportunity to give us more feedback to continue to refine the approach.
And I give you, pat on the back for that for the US government as well, because we often find with governments on really any, basic cybersecurity policies, it can sometimes be pulling teeth to get them to have a substantial public comment period. The fact that you're doing two and on an issue which is really baked within the national security domain, kudos to the US government. And hopefully that can be an example as other governments around the world put out or address similar topics.
Not looking at any government in particular.
No names named.
Well, I didn't say anything. Okay, I agree, though. Thank you for, running a truly democratic process. We like that. So do you identify specific countries now?
Yes. So the advance notice of proposed rulemaking suggests 6 countries that we are considering designating as countries of concern. Those would be China, Russia, Cuba, Venezuela, Iran, and North Korea. And I would note that those are the same 6 countries that were identified in the Commerce Department Supply Chain Security Regulation. But more importantly, they're the 6 that we think have the intent and capability to essentially exploit Americans' data in a way that harms our national security.
Okay, which obviously makes perfect sense. So you've had one comment period, but it just closed. And so do you have a view of like what level of comments you got back and sort of how well received this is?
So I'll turn this a little bit, but just say, here's what I haven't heard yet in the comments. There has not been sort of ferocious objection to this concept in the comments.
Fantastic.
Which I think was kind of what we were waiting to see play out. Have we certainly heard, comments that would suggest, well, shouldn't this be bigger to address the systemic risk you're trying to address? We've heard that. We've certainly heard some comments on the other end that have said, wouldn't a privacy law do a better job at addressing this risk on the front end? All sorts of the things that are part of the calculus as we refine our approach, but we haven't really heard sort of visceral objection to the proposal at this point.
That's great. Congratulations. And was there a specific trigger that led to this?
Sure. So it was a confluence of things, right? Up until 2021, this issue was one that was permeating predominantly through reviews in front of what's known as the Committee on Foreign Investment, CFIUS, which reviews certain investments for national security risk that involve foreign investors. And we'd seen numerous cases where this data risk was coming up over and over again. Similarly, in a different national security body, Team Telecom, which reviews sort of telecommunications national security risk, we were also seeing similar issues coming up over and over in these reviews. And it was sort of led to this recognition at DOJ, at DHS, and within the administration about the need for a more sort of holistic approach that would address this kind of risk, right? And so that began this 2.5-year process of thinking about how do we come up with something more systemic, like using the rulemaking authority to address this risk through more categorical restrictions, as opposed to trying to address the risk in specific transactions that happen to be within the jurisdiction or purview of the U.S. government to review and mitigate.
Right. So not like an export control where you have to go individually each time and ask for permission, right?
So this would be, I would say, more, I think, looks a lot like our OFAC sanctions regime, right? Where we put categories of prohibitions in place. Now, there will be, similar to export controls, things like licensing, where you can seek an exception from us if you believe there's some negative impact that warrants it. But I think you're looking at more of an OFAC regime.
Right. Okay. Very cool. So just for people listening, I think, Lee, you've mainly been answering the questions. And when we started, we mentioned that Grant is working on the security requirements. So how does that plug in? When does your bit begin? And what are you looking at doing?
Yeah, sure, Jen. So in order to answer that, we need to talk a little bit about the regulatory structure of the Envision program. So the program imagines a set of prohibited transactions, which are transactions that would be outright prohibited. And those transactions are, envisioned to be a sort of narrow set, for example, involving human specimen data and a few other categories that are just outright prohibited, but a broader set of transactions, which are called restricted transactions. And those are transactions which are prohibited unless the entity engaging in the transaction complies with the set of security requirements, which is what CISA is tasked by the executive order in drafting. And the ANPRM that Lee referred to envisions that those restricted transactions could be things like investment agreements, vendor agreements, or employment agreements, or other categories that the DOJ could determine in the future. And the idea is, hey, these transactions have some nexus with legitimate commercial activity. It wouldn't be appropriate to outright prohibit those transactions, but we do think we need to impose a set of conditions or restrictions or security requirements to ensure that they are implemented in a way that doesn't sort of keep that front door open that Lee was talking about. So the security requirements that we propose seek to address the national security and foreign policy threats that arise when countries of concern and covered portions access the bulk U.S. sensitive personal data or government-related data. And we're trying to manage that risk through the requirements. It's important to note that the EO calls for doing this as much as possible without disrupting general U.S. policy commitments to free market and international trade. So we're trying to, target a core set of national security risks that we have identified through these requirements. The EO also says, and we will propose the security requirements based on existing frameworks, such as the NIST Cybersecurity Framework and the NIST Privacy Framework, which I think many listeners of your podcast are probably familiar with.
Yep, let's hope so.
Yeah. And we've said in the ANPRM that they will leverage techniques such as logical and physical access control, certain kinds of encryption, data minimization, and privacy preserving or privacy enhancing technologies to implement the outcome. So basically creating these set of requirements that if an organization demonstrates compliance with, they're allowed to engage in these restricted transactions, but the requirements would minimize or control the risk of this sensitive covered data being transmitted to countries of concern or covered persons.
So just first and foremost, a shout out again. Wow, I'm really patting USG on the back, but for that call out for support for data flows, I think there has been a question, even amongst some of our closest friends around the world, with some of the steps that USTR took to sort of quote unquote preserve space for the domestic policymaking process. I think, this it was very important that you all incorporated into the ANPRM a clear USG position that we support data flows writ large with certain caveats around obviously sensitive data and national security concerns. So I think that was really positive. I had a question on the security measures piece, and I believe this is ultimately going to flow through Team Telecom, but the transfer or the use of submarine cables, and I think probably Hong Kong is going to be the biggest example of this, right? Where you've got significant amount of subsea cables going into part of Chinese territory. It was typically a hub for the region. I know that that is a potential cause for concern, and there are efforts to diversify. But I wonder if you can speak to, on the security measures piece around subsea cables, what is going to be a natural reference point there for what expectations you're making from security measures perspective of the folks that run those cables?
So just for some context, in my previous role, before I started implementing this EO, I used to serve as the chair of Team Telecom for DOJ. And so that provision in the executive order that speaks to cables tells Team Telecom to do three things. First is to conduct reviews of existing cables that land in a country of concern. And so you referenced Hong Kong. You could envision existing cables that have a landing point there might be something that Team Telecom would look at as an example. The second is to review existing cable licenses for cables that have country of concern owners in the consortium, so that one of the owners is one that is owned by or controlled by one of these designated countries of concern. And the third, and I think gets to, Alex, the question you're asking, which is that it requires Team Telecom to issue public guidance that talks about how we see this data risk playing out in the subsea cable space and the types of mitigations we think are effective to addressing it, right? And so that will be something that is released to the public and will allow the cable operators to get, we'll call it more like a peek behind the curtain. What is Team Telecom thinking about when it looks at this kind of national security risk as it pertains to submarine cables?
Excellent. So 1 and 2 there, we can expect those all somewhat happen behind the curtain, right? That's a dialogue between you and either the owner, the owners of existing cable infrastructure. And then that third one is something that's going to play out somewhat more in the public domain, in at least we'll know what the criteria they're using are or the expectations are. Is that fair?
That's correct. I think for the first two, what you'll eventually see would be recommendations to the FCC indicating what should happen with those existing licenses, right? So Team Telecom could make a recommendation to modify mitigations on those cables, to divest an owner, to potentially revoke the license. You'll see something like that in the public domain, but most of that work will happen behind the curtain, whereas the guidance piece will be more of an iterative process with the cable operators and the broader public.
And is it fair that, as with the work that CISA is doing, at least from a technical perspective, we can expect to use existing security frameworks? So, the NIST cybersecurity framework, privacy framework, and so on? Or is it going to get much more into the technical controls kind of level?
I think, and Grant can speak if he's got a different view, but on the team telecom piece, I think you're going to see guidance that speaks more around the types of mitigations we normally use in some of the cable mitigation agreements, right? Which get, not just encompassing those frameworks, but talking about things like physical and logical access controls to secure who has access to both the cable and the information on it.
Yeah. And I mean, the security requirements are going to be based on those frameworks. That doesn't necessarily mean they're word for word taken from the frameworks, but they're going to be based on the frameworks, and they're going to, again, communicate what we think is necessary to manage these risks, in the broader context that we just talked about. And I'll just note that, submarine cables get a lot of attention. They are obviously a very important thing in the global economy. There's a large number of different sort of technical use cases and situations that we're contemplating as we think through exactly how to shape this.
Can I just jump in there? So this is not just aimed at the submarine cable companies, right? It's broader than that.
No. So that one part of the executive order, which is the separate provision than the regulatory program we were speaking about, is aimed at risk in cables. But if you look at the proposed regulation more broadly, the prohibitions are aimed at data brokers. For example, data brokerage between U.S. persons and countries of concern, transfers of genomic data between U.S. persons and countries of concern are also prohibited. And then the restricted transactions, as Grant mentioned, covered 3 commercial relationships: employment agreements, vendor agreements, and investment agreements. And those are sector agnostic. They apply across the U.S. economy.
Right. So this is, really, really broad in truth then, in terms of who it impacts.
It is and it isn't, right? So in terms of the swath of economic activity are sort of broadly defined categories. But remember, put that through the lens of 6 countries, right? And certain persons owned by or controlled by those countries, right? And certain types of data, right? 6 buckets of sensitive personal data, and over certain thresholds of that data to be considered a data set that's regulated, right? So that's where the tailoring comes in.
Cool. Yeah. That makes sense. But so if I'm a security professional listening to this, what I'm basically getting at is that if you're a security pro, this might impact you. And it might therefore be a thing that you do want to go and do some additional homework on, right? It's not the case that you can definitely, unless you're a security pro in a small to medium that doesn't do business with those 6 countries, which is possible, entirely possible. But if you do business with any of those 6 countries, then this is something you should pay attention to. Is that fair?
Yeah, I think that's right. I think you're going to want to have companies and security professionals are going to want to have a better sense of the type of data they have and who they're doing business with that may afford access to that data. That's totally fair.
I would agree. And I just wanted to add one thing on that, which is the security requirements will also be going through a public comment process, and we are, very interested, right, from those security professionals and frankly from anyone, but in particular from security professionals on, situations and use cases in terms of how those security requirements might apply to certain kinds of commercial activity, so that we can fully understand, any unexpected interactions and things like that. So we absolutely, those professionals, when they're getting up to speed on this, if they're so interested, they are welcome to offer public comment on the requirements.
Fantastic. And we won't have a link at the moment because it's not out yet by the sense of things, but when it is out, we will try to remember to incorporate it into the news section so you guys listening know to go and take a look and to get involved.
I guess this is a kind of follow-up to what you laid out earlier in terms of the future public consultations, but do you have a sense of timeline for each of those? Like when the security measures might be out for public consultation, when the second round of public consultations on the broader EO implementation will be out?
So I'll talk more broadly and then Grant chime in here. But so the plan is for us to have a proposed rule out by probably towards the end of the summer. And our idea here is to try and ensure that the security measures and the proposed rule are available simultaneously so that the broader public can see how the 2 pieces fit together. It would be challenging to provide input, for example, on our proposed rule if you haven't seen the security measures that we will connect to those restricted transactions, right? And
I can tell you've thought this through.
And so the goal and ensure we can see all of it, that the public can weigh in on all of it around the same time so that they're well informed.
Yeah, I would just say the two fit together in both directions, right? The security requirements are based on categories and definitions in the proposed rule, and you can't really understand the way the whole thing will work from a rulemaking point of view without understanding the requirements. So our intention is for both of these to be out for comment at, around the same time, and to Lee's earlier comment, to that timeline towards the end of the summer.
So for people who are sort of, affected or implicated in some way, what would be your number one thing for them sort of to go do? Or not do, as the case may be. It might be the case that you're like, nothing for the time being, just watch the space. That's okay.
So I would at least think that to begin with is to get familiar with this and consider whether you want to provide comments in the next comment round. I think we benefit from public input. And I think the more that those professionals are willing to weigh in, both on the sort of, the efficacy of the security measures, but then also more broadly on the regulations, we would benefit from that in the near term.
Yeah, I would agree. And I would also say, just in general, right, as a security professional, one of your core responsibilities is to, protect the data that your organization values. It could be of different types. It may not be the kind of data that this regulatory program is speaking to, but, it might be other types of data. But I think, a critical part of that is understanding, what data do you hold? Where do you hold it? Who has access to it? Those are sort of basic questions of cybersecurity governance. And I think, folks, getting a good understanding of that in their organization is only going to make it easier for them to, understand how this proposed program could apply in their situation.
Fantastic. So again, congratulations on getting the EO out and completing your first call for views, which has a complex name that I can't remember. And as Alex said, it's really fantastic that you are enabling people to participate and provide feedback in the ways that you are. We really appreciate that. Thank you so much for coming and talking to us about it. We really appreciate it. We will include any links in the blog that you give us, that you want us to include. And we hope that maybe we can speak to you sometime in the future to get an update on all of this.
Yeah, that sounds great. And thank you for having us.
Yeah, thanks, Alex and Jen. It was really great to be on.
And now we come back to Michael, who's been patiently waiting for his opportunity to share in my regular dose of humiliation. So, Michael, thank you.
Well, that's totally worth waiting for.
You're right, absolutely.
It is worth waiting for. Definitely.
I feel like we should give badges out. So, Michael, thank you for being our Mystery Trivia Master this week. What have you got for us? Bring it on.
Oh, well, so, I was thinking about what I could, there are lots of different trivia I could do back from my White House days, but that seems almost unfair. So I was actually thinking about, since I'm a Gen Xer, I was thinking about, movies and the connection of movies.
Okay.
And, I was thinking about, so what was I'll narrow the time frame for you. So a good 1980s movie that showcases the dangers of a hard-coded default password.
There's candidates, right? Because there are a few films from the 80s that showcase hacking of some variety and the interaction with systems. I'm trying to think about one that specifically leans in on a password issue. So, I mean, if you're in cybersecurity circles and you're talking about 80s movies, you're going to be talking about war games, obviously, top of the list. But you could be talking about Superman 3, which I like to bring up regularly, just so that people look at me as if I've lost my mind.
Ooh,
right?
That's good, but that's not the answer.
I don't think it's either of those. So I'm trying to think what else is 80s.
Can we confirm it's not War Games? Because War Games is the only answer I've got.
It is not War Games. And so it's not even really a specific hacking movie. That's what makes this so interesting.
That's the thing, right? It's not Ferris Bueller, is it?
No, it's not, although that would be a good one.
These are some great guesses,
there is a bit in Ferris Bueller where he hacks the system.
Yes.
Tron?
Ooh, you're getting closer.
And now I think I'm just naming 80s movies that have a slight tech angle. So I think unfortunately I might have to say that you're going to have to tell us.
Absolutely. So actually, if you think about what happens in the movie Star Trek II, The Wrath of Khan, in that movie, after Khan takes over the Reliant, they fail to change Reliant's default password for their computer systems.
Rookie error.
And so what happens? Kirk and the Enterprise, even though they're badly damaged, they use their knowledge of that default hard-coded password in the Reliant to bring down the Reliant shields and strike back.
Yeah.
So, and that's like from 1982.
This is fantastic. Firstly, this is a great trivia question. I love it. It's a fantastic trivia question. Secondly, it makes loads of sense.
So chalk up 2 more zeros for Jen and Alex.
Yeah, thank you so much for the question. And this is one we didn't offer to Inez because, let's face it, she wasn't born when that movie came out. I'm sorry, Inez. Not that you can't watch movies from before you were born, obviously. Michael, thank you so much for joining us through the episode. It's been really fantastic hearing from you and connecting on these topics. Hopefully people will go and check out Circia and think about responding to the call for views. That just leaves it for me to thank again my fabulous co-host Alex Botting and our wonderful producer Inez, and you, our lovely listeners. Please continue listening. We love you, and we'll talk to you next episode.